Hey, Mom, do people have to go to a lawyer for their will? I mean, can't they write it themselves? They already know who's going to get their things and who they want in charge.
Yes, James, DIY estate planning. I've seen it a lot. And yes, people can do it, but they often get it wrong. Some people just write out exactly as you said. I know who I want this to go to, and I know who I want in charge. And they handwrite it well. Illinois does not accept, that's called a holographic will. So it's not possible to do that in Illinois. Other states will accept them. Illinois does not. And it's not to protect our profession that you must come to us for wills. But the reason how wills are put together is so strictly construed, as we say, is that this will is not going to be determined or probated or people getting gifts until you're gone. And when you're gone, it's too late at that point for us to determine what you really meant. So that's why wills have to follow a very strict format. And I will tell you, there's a couple of very popular DIY online programs that people can buy to do their own wills and trusts. And two of the most common do not comport with Illinois law. So Illinois' probate court requires the attestation clause of a will to say that the testator, the person making the will, is of sound mind and memory. Those two popular programs do not say and memory. I've had those wills after someone passed away. I've had one judge say, well, I'll admit it, but if anybody contests it, it's out. And I've had a judge in Will County say, I am not admitting this will to probate. It does not comport with the Probate Act. So it's possible that the document isn't even going to comport with our current law. And then there are a couple of other things that can go wrong. Sometimes they'll not be properly signed or witnessed. So Illinois requires two witnesses, no notary. I've seen many where they have one witness and one notary. So it's a matter of getting the document properly drafted. And then, even if it's properly drafted, those who do the will by themselves often don't think through what we think through, because we see this all the time. They'll put in whom they want in charge and they'll forget to put in backup because that person might not be there when the time comes. They'll say whom they want to get the gifts, but that person may not be there when the time comes. So I often see common mistakes that I see in DIY wills is lack of backup. And then the other part, James, is we don't know what we don't know. So you might think, I'm determined to do this will and I'm going to get it right and I'm going to read up on the law and I'm going to not make any of those mistakes that I had previously talked about. But what if the will isn't the right document at all? What if you need some other kind of a plan? What if it's a trust that you should be doing? Because of all our years and experience in estate planning, we know how to avoid probate, which needs more than a will, we know how to save taxes. We know how to prevent family feuds. We know how to prevent claims against the estate. So you may, as we say, you may not know what you don't know. So your own legal documents may not be the best place to start with saving some money. There was this great book that came out in the early 2000s. It was called The Millionaire Next Door, and it's chock full of the clients that I see day after day. And the writer of that book, in describing the people who lived their lives frugally, they didn't waste. They were not spenders, they were savers. But the one thing they knew to save those assets, accumulate those assets, protect those assets, was to invest in good tax, financial, and legal advice. So that's my advice for today. Thanks for watching. I will see you again tomorrow.